Excited Utterance, the Evidence and Proof Podcast, Episode 169, Yan Fang, Internet Technology Companies as Evidence Intermediaries. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Yan Fang. Yan is assistant professor of law at Boston College Law School, where she writes and teaches about privacy law, evidence, and law and technology issues more broadly. Our podcast today features Yan's new article, Internet Technology Companies as Evidence Intermediaries. It was published last year in the Virginia Law Review. In it, Yan explores the place of Internet companies in our system of evidence. Internet companies, familiar names like Google, Meta, and X, increasingly hold vast quantities of information. And some of that information invariably becomes important and relevant for parties in legal proceedings. Yan's article thus studies how staff at these companies respond to legal requests for information, whether that's from search warrants or subpoenas or other legal processes. My conversation with Yan explores this often underappreciated, but clearly important and pervasive part of evidentiary practice. In a way, it's a glimpse of the future, but perhaps the future is already here. Yan, delighted to have you on Excited Utterance. Welcome.
Thank you. Excited to be here.
I think it's important to begin with some context on your article. It's about internet technology companies and their role as evidence intermediaries, as you call them. What do you mean by evidence intermediary, and why is this an important issue to pay attention to?
So, evidence intermediaries, they're third-party organizations that often have a lot of information, a lot of different people. So you can think about them hospitals, banks. This paper focuses on internet technology companies who have a lot of information and data about people. And as a result of having that information about people, routinely get demands from legal actors for evidence, whether through search warrants or through subpoenas and other kinds of compulsory demands.
And you mentioned banks and phone companies. I think most of us are familiar with those traditional analogs. Why are internet technology companies potentially different? Are they different? And again, why are they an important thing to look at?
So they're different in a few ways. I think one is they have a lot more changing forms of data. So you can think about internet technology companies as primarily providing services, they create software, and the features that they have in that software, whether the website often or mobile apps, they can change really easily, which means the kinds of data that they collect can change, and often the back end of how the data is stored, how they're connected, that also changes. And that's really different from kind of more traditional intermediaries like banks or hospitals, which tended to collect more static categories of information. And when records were more paper form, those kind of tended to change less. So the services at healthcare providers tended to be more similar. They weren't radically offering new procedures day in or on a monthly basis. And technology companies and the services they provide change more, which means that the information they have about people varies greatly as well. And why that's important to study is that what it really means for evidence in our evidentiary environment, it means that actors who are trying to obtain and use evidence, there's a lot more they have to learn about what kind of information may exist, what kind of evidence they may have to obtain, and critically, what to call that information when they're trying to obtain it. And so I think because the kinds of data change so often, it means that all kinds of evidence seekers to do a lot more work to keep up. It also means that for kind of the intermediaries themselves, they might be getting more requests that are difficult to understand or that don't quite fit with the current sets of data that they have.
So, how does the current legal regime work in this context with the evidence intermediaries? So, someone who's not enmeshed in this field might say, well, it doesn't seem like a typical Fourth Amendment type of case where you have a defendant who is actively resisting a search by the government. What you have here is a third party. Can the government just subpoena this information? Or in the alternative, if the information provider wants to assist the government, can they just give it to the government?
So the main kind of legal landscape that governs this is the Electronic Communications Protection Act, ECPA. And under that set of statutes, depending on the kind of data that law enforcement agent wants to obtain, they can obtain it. So, for example, if they get a search warrant from a court, then that search warrant goes to the company, and that company is legally compelled to provide responsive information in response to that search warrant. If, for example, criminal defendants or civil litigants wanted to obtain data, the current law is primarily that they cannot obtain the content or the substance of communications, but they can receive other information. So, for example, about when messages were sent or who sent them, they can draft their subpoenas or in cases obtain court orders, and then companies are compelled to respond to those types of demand. There are a few circumstances when companies can disclose information without receiving formal legal process. So under ECPA, there's an exception for companies trying to protect their own data or trying to provide services. And in some of those cases, although we don't hear about them publicly very much, they do have some leeway, for example, if they're investigating fraud on their services, to provide some of that information absent compulsory process.
As part of your paper, you did this fascinating set of interviews to understand, for lack of a better term, what's going on in practice. And you interviewed compliance staff at the tech companies and law enforcement officials. So let's start with the compliance staff. What did you learn in your interviews with them?
I wanted to speak with the compliance staff because they are the people inside companies who receive these kinds of demands. And so they're encountering them and running into different kinds of informational and communication problems when they are trying to figure out what to produce. As I mentioned before, when officers prepare an application for a search warrant, they tell the judge they have to write out in their application to the judge what the case is about, what data they're seeking. And so there's kind of a complete sense of what they're trying to do in this case. When companies receive search warrants and they're trying to figure out what to produce, they don't actually get a copy of the underlying affidavit, which may contain sensitive information or just people's identifying information that gives them a sense of what the case is about. And all they receive is the actual warrant itself, a document that lists the categories of data being sought. So it may say you're investigating this kind of case in violation of this particular statute. We're seeking account login information, any associated payments, any kind of geographic location that you may have versus they've been communicating with. And often what happens is that the language in those warrants can not match with the actual data holdings that companies have. Let me give you an example of what people often talked about. So during interviews, a lot of the compliance staff, or sometimes they're also called law enforcement response teams, they will say that a search warrant, for example, sought information about a buddy list associated with this account. And buddy list is an older term that was associated with, if you remember, America Online's instant messenger. And it was a list of people you chatted with or messaged often. And this is the kind of language that officers often use to try to get a sense of who someone's frequent contacts are. But for some companies, they might have a lot of, they may not call that buddy list information. They may call it contact list, most frequently contacted list, friends list. They may have different tiers of people because different social media applications, for example, may have people you are in contact with in this setting, but a different list of people you're in contact with in a different setting. And so when they get warrants that just have general language like buddy list, they're trying to figure out how to match it on with the data that they have. And so when they try to do that, they often may have to kind of reinterpret buddy lists. So some companies may call an officer and tell them, hey, we don't have this kind of buddy list, but these are the other forms of contact list information that we have, which of these you're seeking. Others may just say, hey, you called it buddy list. That is not the kind of data that we hold. We're just going to say we have no responsive information. In other cases, people reported that they would just kind of take a best cut. This is the most frequent type of thing that our product is known for. So this is just the first cut of information that we will give to the officers in response to the search warrant. And if no one follows up, then we're done. If someone follows up, maybe we'll look further and provide additional data that falls within that category. And so that's one example of the kinds of challenges they encountered when trying to figure out what to produce in response to a warrant. The facts ultimately they kind of know very little about.
This phenomenon that you identify here is what you call in the paper knowledge misalignment, or at least that's your description of what's going on. Part of it is linguistic, buddy lists versus friends list versus contact list. And then some of it is also substantive and practical, which is that the law enforcement officials know or think that they know the information that they are looking for, but they don't really know what the technology companies have. And then the technology companies have a bunch of data, but sometimes the law enforcement officers don't know to ask for it.
Exactly. Yeah. And so this is the kinds of mismatch that occurs when you can think about this production of search warrant as kind of a joint task that these people in different institutions, different organizations have to undertake. And each person just has part of what they know, and they don't necessarily want to share what they all know, right? So some of the companies don't necessarily want to share and disclose to the officer all the different types of data that they have. And an officer doesn't necessarily want to share and can't in many cases what the substance of the case is about. And so they're both kind of working with a different set of knowledge and trying to come together to produce something that's responsive to the search warrant.
I think another interesting facet of what you found was oftentimes we characterize, or the media or critics characterize tech companies as either resisting law enforcement or helping law enforcement. And at least the way I interpreted some of your findings, it was that the tech company staff are often just simply more interested in either what you might term expedience or convenience. And once you pointed this out, I suppose it makes sense, but it was not something that I thought about originally. But that's in many ways how bureaucracies work.
Right. And I think that that is a big part of the story that I wanted to just add to the story. I think when we talk about relatively powerful actors, engaged in on the company side, a lot of kind of commercial data gathering, on the law enforcement side, kind of gathering for criminal enforcement purposes. I think when we look especially at kind of the macro and the big litigation or news stories that come out, it does seem like the key forces are whether values of the companies or actively trying to resist or to assist law enforcement. And I think that when we look at how organizations really interact, a lot of it comes down to resources. And it also comes down to interpersonal interactions and then work related matters, whether it's through efficiency or through conflicts that arise. And a lot of how companies are trying to think about how to produce, especially the companies that receive, tens and thousands of these on a really large basis, is trying to figure out a way they can produce evidence that's responsive but also efficient. And so they're not using too many organizational resources trying to find every piece of data that would necessarily be responsive, but at the same time, not provide such incomplete responses such that it might lead to just a lot of follow-up inquiries about, well, I know you have this type of data because, I know at least this is some of what your service does, or I've seen you produce this data in other cases and now not in this context, to reduce that kind of additional follow-up that can arise if you produce too little data as well.
It's so funny. It always boils down to the basic fact that people are busy and they're just trying to clear their desk or their inbox. And this drives a lot of what's going on here. Let me push forward and kind of ask you, what are the policy implications here for what you found? What does this say about these search warrants and whether they are being written the right way and how they can be improved?
I think for me, the biggest thing policy-wise I took away, and unfortunately wasn't one of the subjects that I had studied, but it was really thinking about the role of judges. So the study, was really interviewing law enforcement officers and interviewing tech companies. But as I was thinking through who are the actors that you want and that ideally are supposed to have a lot more say in what is being ordered to be produced here are judges. And there's kind of two ways. There's on the front end, judges are supposed to be reviewing the applications and the search warrants themselves to make sure that the data being sought is relevant to the investigation, that it fits and it's particular. And I think given that the officers who are currently preparing the search warrants themselves now often lack a sense of exactly what data to request, the information that reaches judges also tends to be a bit scant as well. So judges cannot thoroughly evaluate like, exactly what data are being sought and whether it's appropriate in this kind of search warrant context. Now, there is a lot of federal magistrate judges who have a variety of contexts from criminal cases to national security cases who have asked officers to be more specific or to be more narrow in how they prepare search warrants. But I think what this paper identifies is it's not even necessarily just that officers are always just so data or evidence hungry and want a lot, but sometimes they draft broadly in part because they don't know exactly what language companies are using, how they will interpret it, or how the data has necessarily changed. And so I think for both judges and for officers, there needs to be some kind of more of an institutional response that builds the knowledge that they have so they can prepare and review search warrants better. Different scholars have thought about this in different ways. I think at the most easy intervention level might be individual judges in the course of reviewing search warrants, developing expertise and knowledge about the kinds of data that companies have. I say easy not because I think that's necessarily realistic given judicial workload and capacity, but the smallest thing that could be done. And there have been some trainings focused on judges to really help them understand more, even at the company level, what kinds of data different companies might have. And now Within a recent few years, there's also been litigation about geofence search warrants. So these were warrants that were really common many years ago that would go to a company like Google and say, hey, if I want to know what devices may have been with Google accounts may have been in a particular geographic area. And through litigation, I feel like judges have actually developed a good sense of how that works. And so I think on that individual level, judges could, by requiring more records custodians to testify, that might be one way. At the case level, they could learn more about how companies actually review warrants, identify data, and produce responsive data. I think at the more institutional and a kind of a would be a much bigger intervention would be to do what some scholars have proposed is some kind of national evidence body, an organization that would be systematically responsible for gathering information about how different, particularly kind of tech companies with their changing forms of data, how they describe that data, what kinds of data they have, and then disseminating that information, not to just judges so they can better understand what evidence is being sought, but also, of course, to law enforcement, to criminal defendants, and potentially civil litigants as well. Because I think for me, it's really a question of capacity and both evidence requesters being able to do a better job and knowing how to request evidence in a more specific way, and then judges being able to review the kinds of decisions that companies are making about what to produce and what not to produce. What's happening now is that a lot of times, on the whole, search warrants aren't challenged in court and subpoenas aren't litigated in court. So whatever the company decides is responsive or not responsive ends up being the final call. And there's both an opacity to the kinds of decisions and how they make it, and then in some ways an arbitrariness with some litigants or law enforcement actors getting more different data without a sense of why they are getting data sometimes and not getting data other times. And I think what a national body would do is try to systematize that info and disseminate it among evidence seekers.
Curious, I in some ways wonder whether the technology companies would be supportive of this or oppose this in the sense that having law enforcement not know where all the data is or how the data works means less work for them because nobody's asking for the data. On the other hand, it's sure going to be more frustrating when the requests are overbroad or somehow ask for things that are not available or actually very onerous to provide. So it's kind of a double-edged sword. Final question for you. What's next for you on this project?
I'm really interested in how different complex institutionals interact and how particularly organizations and their routines and processes shape the kind of evidence that's available to different kinds of legal actors. So on this project, next, I am really trying to think about the role that companies play in actually kind of responding to crimes that they become aware of, and then how they make decisions about whether something they become aware of users doing on their services is something that should be reported to law enforcement or something that they should handle internally. And so that is kind of one area that I am excited to do more research and look at how they actually act on some of the information and criminal activities that they may become aware of on their services. More generally, I'm really interested in thinking about whether what I've learned here revises some of the assumptions that we have in evidence law about the way that organizations keep records. So we have different kinds of hearsay exceptions that at business records that can look at health records or public records and think about organizations as engaging in some kinds of routine activities and record keeping that make the records generated by those organizations more reliable. And I'm wondering whether, particularly with services that where features change and the data holdings change, we should rethink some of those assumptions about the consistency and reliability of records.
Well, Yan, thanks for taking the time to talk about this fascinating area of internet technology companies and their role as evidentiary intermediaries. Great having you on the show.
Thank you so much, Ed. I appreciate it.
One of the things I find so compelling about Yan's work is that it focuses on the slippage between law and practice and law on the books. Technically, law enforcement requests a search warrant with a certain scope, then it has it approved by the court, and then the tech company implements the warrant. Sounds simple, right? Not exactly. If the language of the warrant makes no sense to the people at the tech company, then law enforcement is going to have a pretty hard time getting the information that it needs. Same with if law enforcement doesn't know what information the tech company has, or even if the information request is too onerous and likely to generate resistance from the tech company's compliance staff. We often like to play at the level of corporate policy or what you might term the law writ large. But how that law plays out on the ground can be quite different than how it plays out in our minds. Someone has to ultimately interpret that search warrant. And if it's too costly to litigate the meaning of those words, then a great deal of power will fall not to the judge or law enforcement or even corporate policymakers, but the person assigned in the field to deal with these requests. And how that staff member experiences the law becomes just as, if not more important than, the legal actors that we normally pay attention to. One other point, which Yan and I spoke about after the interview. Tech companies offer a breathtakingly large repository of potential evidence. And as the common law adage goes, normally the law is entitled to every person's evidence. But that's not quite right in the information technology space. Now, this is emphatically not my area of expertise, but there seems to me to be an asymmetry between the government and private parties in this space. If the government wants geofencing data on the defendant, it needs to get a warrant. But if the defense wants geofencing data on, say, a third party in order to prove its theory of third party guilt, it's not clear that the defense can obtain this data based on compulsory process. Or at minimum, it's going to be a different mechanism with different burdens. Now, these asymmetries do occur elsewhere in evidence. For example, the government can offer witnesses immunity, whereas the defendant can't. But those are arguably narrower contexts. The information that is held by technology companies is vast, which makes this asymmetry potentially more troubling. In any event, my thanks to Yan for a thoroughly enjoyable paper that artfully combines tech with evidence, and that also provides much food for thought as we think about evidence and proof in our increasingly digital world. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.